Oh, thank you. Thanks for telling me I'm muted. All right. So thanks again for joining us, everyone. You'd see from the course outline that the topics, I've moved the topics around a bit. We will, in fact, cover all of the topics. I just thought I would like to get onto something a little more exciting because we've been doing a lot of theoretical stuff. I wanted to get, and as much as this is theoretical, it's something more of a practical nature. And I thought that it would just shake things up a bit for us to deal with this now. So today and next week, we're looking at methods of securing the attendance of the accused in court. Generally, what are we talking about and why is this even important? Why is it important that the accused appear in court? Why do you think the justice system needs an accused person to be at court for the trial? Well, it's part and parcel of what we talk about when we talk about constitutionalism, constitutionality, uh, the right to a fair trial, the rule regarding audi alteram partem, the fact that in a criminal trial, the stakes are much higher than in a civil matter, and the decisions taking actually do violate, can potentially violate various human rights. And if you're given a sentence that is a custodial sentence, in other words, sentenced to serve time in prison, that is a violation of your right to freedom of movement and various other rights. So it is important that the accused person be present in court for his trial. But we know that it is not always possible, and it's not always that an accused person will voluntarily come to court to stand trial. Some may attempt to evade trial, abscond, and that then prevents justice from happening. And now again, we're looking at it from the perspective of justice for the community and for the victim of crime. Now, there are various ways in which an accused person's attendance at court can can be secured, right? Can be secured, and we will talk about what those different ways are. But when we talk about constitutionality and when we talk about efficacy, we're asking ultimately, what is the purpose? What is the reason why we need this accused person in court? What are the different ways in which we can ensure that an accused person does come to court? Which is the the least restrictive way of doing that? Which is the most restrictive way of doing that? And considering all of that, which is the most appropriate in the circumstances, in the particular circumstances? Now, if we go back to getting to someone to court, it can be done in any of a number of ways. We'll talk about, and you've heard on the slides, we're talking about summonses, written notices, um, and arrests. What you'll also come across very, very frequently in all the literature and all of our discussion when we talk about efficacy of a summons, efficacy of an indictment, of a written notice, of arrest, is this question of reasonableness, right? Reasonableness. And particularly from the point of view of an arrest procedure, um, and when we talk about arrests with warrants and arrests without warrants, this question of what is reasonable for the person effecting the arrest comes into great focus, because this is where, if you're talking about arrests without a warrant, this is where the police officer or anyone else who's been empowered to conduct an arrest without a warrant will have to, ex post facto, satisfy the court that his suspicion regarding whether or not grounds to arrest someone existed was reasonable. And we're going to come back to this question of reasonableness, not only in relation to arrests, but also when we cover the topic on search and seizure. So searching and seizing for evidence where police officers have warrants or do not have warrants. And this stuff will come more clear to you as we look through some of the examples. So let's go through securing the attendance of the accused at court. Like I said, there are various ways in which it can be done. You can use a summons, a written notice to appear, an indictment, arrest, or a warning. And we'll talk about all of these in turn and over this week and next week. And at the back of your mind, we need to also consider constitutionality. Like I said, constitutionality is a big question because of what is involved, which rights are violated. And remember, at the time of arrest or at the start of the trial, the accused person is only an accused person or a suspect. They are not a criminal. They've not been found guilty. So they're not being convicted. They're not a convict. So essentially, they are not guilty. So a violation of rights, the right to freedom of movement, for example, would be justified only if we can show that there was reasonable grounds for that and that it was constitutional. So we'll also have to talk about, when we talk about arrests, we'll talk about the 48-hour period, etc., and the violation of rights pending the outcome of a trial. What would be reasonable? What would be constitutional ultimately? And look at some of the cases and this is why an accused ought to be present at his or her trial. So the first one we're going to look at is what is perhaps the least drastic means, and that is a summons. What is a summons and when is it used? A summons essentially is a written document which warns an accused person or a suspected person that his trial is going to be on a particular date at a particular time and in a particular court, and that he is now essentially being warned and must come to court on that day of his own volition based on the strength of the summons. Failure to attend will result or will have other consequences. And the other consequences, because this is a criminal trial, will not be an automatic guilty verdict, but could then translate into a warrant for arrest. Okay, when is a summons used? Now again, we said, well, what is the purpose of, why are we trying to secure the attendance of the accused at court? Because we want to have the trial, we want justice to be served. We also want the accused person to be able to give his side of the story, audi alteram partem, etc. But a summons is, and that would be the same achievable or the same goal, even if the accused person was arrested in the first place and kept in custody and simply brought to court on the trial date. But a summons is seen as the preferred method in several circumstances. Firstly, it would be if the offense is not a very serious one. Or secondly, if the likelihood of the accused absconding is not strong, right? So we'll talk about those as we move through some of the examples, and it will come clearer to you as you move through the sessions. So step by step, how does a summons work? Again, you can see all the role players involved here. This docket would appear having been investigated. This docket would then come to the prosecutor. Prosecutor looks at it and then drafts properly a charge and hands it over to the respective clerk of the court. The clerk of the court then issues a summons and any other documentation or based on the information received from the prosecutor, states in there the date, place, and time of the trial. And that is then handed over to the sheriff, and the sheriff must deliver it and issue a proof of delivery or return of service to the person that has been is named in it. Be also aware of the dates, 14 days, because if you are the other party representing the defendant, then this summons would not be valid if it was short served. It would be short served. The next type of notice is a written notice. Again, also for less serious offenses, works very, very similarly to a summons and contains pretty much same information as as a summons would. The only difference is that a written notice caters or has within it an admission of guilt. So an accused person can, or the person who has received this written notice can avoid going to trial and instead submit to an admission of guilt, wherein he or she will pay a fine instead of having to go through the trial process. They admit their guilt that way. There are pros and cons to each of those. Now, anyone familiar with what this is? Anyone received speeding tickets, speeding fines?
Yeah, it looks like a speeding ticket, ma'am.
Yes, it is. That's what it is. And the thing with traffic violations is that they are in fact criminal offenses. They are criminal offenses, and you would have received one in the post by either a registered post, or a sheriff would have come knocking on your door and handed over one to you. Now, this is a written notice, right? But it can also take the form of the summons depending on which uh, district or jurisdiction you're in. But for our purposes, let's look at it from the perspective of it being a written notice. And there's all this information. So it tells you that, look, this is the date of the trial if you want to come and fight and dispute this speeding fine. Alternatively, here's an admission of guilt fine that you can pay before that date. And you must pay it before that date at a particular clerk of the court office. And once that's done, this matter is over. But the matter may be over, but having paid the admission of guilt fine, you will have a criminal record. And as an article clerk, that is important. Now, how that works is that if what has been sent to you is a written notice and not a summons, then when you pay the admission of guilt fine based on the written notice, you wouldn't get, this won't go on your criminal record. But if you ignore this, and then you get issued with a summons and then you pay that admission of guilt fine, that's when it goes on your record. So it's not a matter anymore of, oh, just leave it and wait for the summons. As someone who is planning to get admitted at court, don't wait for the summons, because the consequences can be dire for your admission. Just listen to the audio and have a read of what we say about that. Summonses versus written notices. A written notice, the accused is given a choice, and a written notice is made by a peace officer. Summonses are made by a clerk of the court after the prosecutor has compiled the charge sheet, etc., and there's no choice. And when we talk about choice, you can do the admission of guilt fine and not get a criminal record, or you can wait for the summons, at which or alternatively appear before the court date and wait for the outcome. An indictment is very similar to the summons. In fact, it's the same thing, except an indictment emanates from the high court, whereas a summons emanates from the magistrate's court. Right. So what's going to form the bulk of our discussion today and next week as well is this thing about arrests. Now, arrests is being described as the most drastic way, but perhaps the only guaranteed way of securing the attendance of an accused person at court. And that's because when this warrant of arrest is issued, or when a suspect is caught and taken into custody, they remain in custody until the start of the trial and then for the duration of the trial. And so conceptually, you can see that the accused person is there and will always be there. because all they have to do is be brought out from the cells, brought from whichever prison housing facility they've been kept in. But you can also see that an arrest is very, very drastic and it's very severe, because if we consider that you are innocent until proven guilty, then you've got an accused person who spent all of this time incarcerated, right? And criminal trials aren't short. They aren't always short. They take a long time. They can take months, they can take weeks, they can take years, okay? Only to be found at the end of it that the person is found not guilty. Alternatively, they found guilty, but are given a sentence even shorter than the time that they have spent awaiting trial. So use or reliance on an arrest procedure might be a guarantee of ensuring that an accused person is there, but the consequences are dire. And so must only or ought only to be resorted to in very exceptional, serious circumstances. When we're talking about arrests, arrests can happen with warrants and arrests can happen without warrants, right? We would accept that first prize would be for an arrest to be conducted in terms of a warrant, because it would mean that the investigating officer would have had to satisfy before court to a magistrate that, look, this is in fact the person I'm looking for. Here are their whereabouts. And here's all the information that I have, which makes me believe that this person is responsible for a particular offense or particular crime that we are trying to prosecute, or we would like to prosecute. Now, with arrests without warrants, on the other hand, they happen sort of on the cuff, where something happens in front of the police officer, or the police officer, so someone is caught red-handed and then arrested. Now, both are required in order to successfully police and properly police in any society, in any community. First prize, obviously, would be to effect arrests with warrants, but we also know that it might not always be possible or reasonable or prudent or effective to say to an accused person, okay, I see what you're doing. I know what you're doing is wrong. Can you just wait here? Give me 4 to 5 hours or 3 to 5 working days. Just wait here, don't move, while I go to court and get a warrant for your arrest. Now, that's ridiculous, right? So it's not always going to be possible. So in the circumstances, and we'll talk about reasonableness, we'll come back to reasonableness, right? Where a peace officer effects an arrest without a warrant, it is very possible, and even with a warrant, for this person who's been arrested to allege and make a claim that I was unlawfully or wrongfully arrested, and I want justice for that. In which case the police officer who effected an arrest without a warrant would have to prove that his suspicions, etc., were based on reasonable grounds, that he reasonably expected or suspected that a crime was happening. Yeah, so arrest can be lawful, and listen to the audio, what we say about that. A police officer effecting an arrest must also exercise physical control over an arrestee. Now, physical control goes as much as placing a hand on or placing a finger on and exercising control. Bear that in mind for what we say regarding use of force, which we'll talk about next week. And only as much as is necessary. Only as much as is necessary. We must avoid the excessive use of force. An arrested person or person being arrested must also be informed of the reason for their arrest. Look at the various cases. And usually when a police officer has a warrant of arrest, he must verbally say to the person, this is why I'm arresting you. And once the arrest has been conducted, hand over a copy of the warrant of arrest. And we'll talk about that same procedure when it comes to search warrants as well. What's important is also that once a person has been arrested, they must also be taken to the appropriate authorities as soon as possible. So just because you've been arrested and placed in a police van doesn't mean that you can be driven around the whole of Maritzburg for the rest of the day, or whichever the district is, or even be made to sleep in the police van. You must actually be taken to a police station and placed in the holding cells properly. And look at the case of Ezekiel Wasakinock for that. Now, what comes down to, and this is a big question, which you'll also see from your tutorial question, is what is the purpose of an arrest? Can you tell me what is the purpose of an arrest? And it's the same question I could ask is what is the purpose of a summons? What is the purpose of a written notice? What is the purpose of an indictment? What is the purpose of an arrest? Because it is only this object or the purpose pretty much which legitimizes effecting an arrest. We've already discussed that an arrest is very drastic.
Good morning, Ms. Pamji.
Good morning, Tinashe. Go ahead.
Well, I think arrest, the purpose is can only be seen in instances where there's reason to believe that the person is a danger to society, or the person might flee actually from the incident that has happened.
Well, those would legitimize why we're using an arrest over a summons, right? That will legitimize why we've decided that we're going to use an arrest instead of a summons. But the question perhaps I ought to ask rather is, why do we use a summons? Why do we use an arrest? And why do we use a written notice? What is the objective of each of those? Go ahead, Michael.
Well, Ms. Pamji, I think that we issue a summons and a written notice and so forth because in the instance of preserving an individual's, whether it's an accused or whatever, you're trying to preserve an individual's rights in terms of arrest and detention and so forth, and their right to a fair trial and all that there. And also not to be, how do you say, regarded as an accused until proven guilty or something like that there. But we trying to preserve their rights. And so if we arrest the person, we're basically saying that, okay, we do believe to a certain degree that you are that you are the accused, but we're gonna try this first before we take any further steps. So it's more or less to limit their rights because by not doing so, you're gonna infringe the rights of others. So it's like a weighing up of interests, I guess.
Not quite. Go back to what I asked. I'm basically saying it's the same object. We have the same objective. The same objective can be achieved through using a summons, can be achieved through using a written notice, can be achieved through using an arrest. What is that objective? Okay, who has their hands up?
The objective is...
Oh, Alwechu, go ahead.
The objective is to bring an accused person to court.
Court, exactly.
Yeah.
Exactly. We want to bring an accused person to court, and we can use various or a suspect person to court. And what that means is that we have every intention of the trial starting, that he or she will be formally charged, right? And then this adversarial process of determining guilty or not guilty will begin. But we can only do that if the accused is in court. But like we said, there are various ways in which we can do that. We can use a summons, we can use an arrest, we can use a written notice, right? So the purpose in determining whether, one of the ways of determining whether or not an arrest was necessary, right? And whether the arrest itself was legitimate is starting from this question. What is the object of the arrest? Is the arrest just to harass the accused person? Or does it have a legitimate purpose, legitimate intention of bringing this person to court for their trial? And if you look at some of the cases, Tsose in particular, the question is, well, would the milder or any of the milder approaches have achieved the same purpose? Now, when you look at the tutorial question, so I want you to please bear in mind the tutorial question you need to be considering. Discuss the purpose of arrest in light of the decision in Sex Worker Education and Advocacy Task Force versus the Minister of Safety and Security. That case had to go back and say, well, look, is this a legitimate arrest? Did the police officers entertain the intention or have the intention of bringing these suspects to court for their day in court? And that's essentially what the rest of the tone and flow of these slides are that we're talking about, okay? Yes, what is the object of the arrest? Is it merely to harass them? And you look at several of the cases where instead of, ensuing on a proper court processes for eviction, someone gets their police buddies to just repeatedly arrest farm workers. Arrest them, keep them overnight, let them go, arrest them, keep them overnight, let them go, such that these people that are being arrested eventually get frustrated and just leave the property. Okay, so look at those cases and see where the legitimacy, and there's another case, Duncan versus Fankert, etc., that you must look at. Where does this power to arrest, whether with or without a warrant, come from? Well, it's been codified in Section 40 of the Criminal Procedure Act, and through the case law, as to what is required for an arrest to determine whether it was appropriate in the circumstances, what the procedures are involved, and when we look next week's session as regarding the use of force in Section 49, all of that will come more clearly to you. But the ultimate question of whether or not it was correct in the first place to resort to arrest as opposed to a summons or a written notice comes down to the question, would the same object have be able to be achieved through use of a milder method, in other words, the summons or a written notice? And again, it does come down to the factual scenario, whether or not the circumstances were such that it necessitated an arrest immediately. I remember an arrest can then subsequently result in release on warning or release on bail pending the trial date and pending the outcome of the trial. So arrest doesn't also have to be indefinite, but we will, and that will become more clear to us as we move on. So you can look at all of this. I'm not going to go through it now because it's on the audio. Let's get into this question. Discuss the purpose of arrest in light of the decision in Sex Worker Education and Advocacy Task Force versus Minister of Safety and Security. How did you deal with this question? So yes, this is what type of question is this? Yes, it's an essay question. What type of essay question, Owetu? So it's just easier for me. There's too many screens I'm looking at. So if you just raise your hand or just unmute and speak, I'm happy for that to happen. I don't want to miss anything. What type of essay question?
Yeah, I'm not sure what type of essay question it is, but what I know is it's an essay question.
Okay. All right. Well, let's just take our cue from there. I've left my stylus at home today, but anyway. So you've been given a case, right? You've been given a specific case to look at: sex worker education, etc. So you're looking at doing a case summary, but more than a case summary. So this is what you'd be calling a case note. So you've got to look, and in relation to that, you're meant to be dealing with a particular issue, right? If we go back to FIRAC, a particular issue that this case dealt with. So in this question, you're discussing purpose of arrests, right? What makes an arrest lawful? What makes an arrest unlawful? But more specifically, going in on purpose and what we've just discussed about the purpose of an arrest must be to bring the arrested person before court. So that will inform how you summarize the case, but more importantly, and for the purpose of the bulk of your marks, is what did the court say and what does the law outside of just this case say regarding the purpose of arrests? How did you deal with it? Go ahead, Tandukwazi.
Okay, ma'am. Dealing with this question here, I think the best way to tackle this question here is to discuss the purpose and say that the court or the police, they use force to harass the women there. Is it the case? Is it the case about the women that were arrested for like being prostitutes or what?
Yes, that's the case.
That's the case. Okay. So the purpose of arrest was not to detain the person in question because of they violated a specific certain type of law, but the police were to harass them.
To harass and inconvenience them, correct? I say you're correct so far.
Yeah, but then I'm not prepared. You know, I'm still in the pot. I'm cooking.
Okay, no problem.
So I'm trying my best. You know.
You are multitasking. Yes, no, I'm very pleased. So you've identified the correct case. You've at least read it, okay, and you've identified the circumstances under which this became a question. And if anyone else has read the facts and wants to enlighten us, what happened here is that in this department, in this Western Cape Police Department, women who were sex workers were being arrested repeatedly, kept in custody, and then released from police custody. And that became, or in their view, was a form of harassment to force them to stop doing their jobs as sex workers. They brought before court an application to interdict the police services from conducting further arrests because they said that it amounted to harassment and was harassment with no legitimate purpose to bring them before court because the police officers themselves were well aware that these sorts of cases never went to court. The police officers, on the other hand, in court, turn the argument around. They say, no, we've arrested these women with the intention of bringing them to court. It is not our fault that the National Prosecuting Authority just didn't. So have a look at this case, and there's some criticism to be made of the judgment itself and what the court ought to have pronounced, because one of the criticisms being that a court cannot tell police officers not to do their jobs. In other words, how they phrased it was that the court cannot tell police officers not to conduct arrests of people who are in the process of committing crimes. All right. So again, remember, I've always said that you must work smart, not hard. Sorry, not this one. That's the actual case. Work smart, not hard. And so if you have worked smart and not hard, let's stop this one. Where's it gone? Just give me a second here. You would have seen that we uploaded this article by Professor Friedman and the late Professor Grant, which is a case note done on this exact case. And so they've, like I said, with case notes, some other academic has done the thinking and has put their thoughts and their criticisms down. So for a well-rounded answer to that question, have a look at this article. And there are other articles written on this as well, but this was a nice short one for our purposes to get the ball rolling. All right, so anyone, I'm sure I put that up onto Moodle for you guys. So if you've done your readings, you would have come across that as well. All right, any questions before we move forward? Because we've done pretty much with the slides that I wanted to raise for you. When is your assignment due? Assessment due? Is it due on the 26th?
Yes.
Okay, and I trust that you are all working diligently towards submission of that. Oh, silence. That worries me. Okay, so what I am willing to do then in those circumstances is we are due to have a Zoom session next week on the 20th, right? We'll postpone that one. We won't have the session on the 20th so that you can use that time to work on your submission. Then you must submit on Monday the 26th, and I will see you all in Zoom class on the 27th. Is that suitable? All right, so thanks everybody. So now you know the arrangements. We won't have a Zoom session on the, what is that, the 20th? We won't have a Zoom session on the 20th, but I will see you all on the 27th, having submitted the assessment. And that gives you enough time to also work on the assessment and also prepare for next week's, the following week's Zoom session. All right, any questions moving forward? Any questions about the assessment or anything else?
Ma'am,
Yes?
with regards to the third question, would I be wrong if I included the Tsotse case that
Absolutely
discusses?
correct. Absolutely correct. Because the this decision in sex workers relied heavily on the reasoning that came out of the Tsotsi case, right? Where Tsotsi, other cases, Duncan, but predominantly Tsotsi, elaborated and pointed out what the requirements were for lawful arrest, particularly around the question on purpose. So you're absolutely correct, Olwethu.
Okay, thank you.
All right. All right, so can we say our goodbyes? And I will see you again on the 27th. All right, thank you, everyone.
Bye, Ms. B.
Bye-bye.